Hi friends, this is CMA Deepika Bhugra Prasad, insolvency professional. The code IBC 2016 has been achieving milestones, and one of them being the amendment to treat home buyers as financial creditors. This one amendment has brought about a massive change in the real estate sector in our country. Friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the code IBC 2016 and to navigate through the intricacies of its proceedings. So let us today discuss one such real estate case. So this is the case of Shailendra Agarwal versus Asit Upadhyay and others, which was decided on the 23rd of April 2025 by the Honorable NCLAT. So what were the questions before the Honorable Court? Whether the corporate debtor's failure to hand over the possession of the flats and its continuing default in refunding amounts to the allottees constitute a continuous cause of action. Whether the allottees remain financial creditors under Section 5, subsection 8F of the Code, even after obtaining recovery certificates. Whether a mere assertion that some allotments are disputed would meet the rigorous standard required to invoke Section 65 of the Code, and whether a corporate debtor can evade its pre-existing commitments by merely undergoing a change in its legal structure. Now let us see the factual background of this case. In 2012, Nikhil Homes Private Limited and Ma Mansa Devi Sehkari Awas Samiti launched a housing project, namely Nikhil Park Royal, consisting of 5 towers at Agra. A tripartite agreement was executed among Ma Mansa Devi Sehkari Awas Samiti Limited, which was the landowner, Nikhil Home Associates, which was the developer or the constructor, and Nikhil Homes Private Limited, which was the marketing company, on 20th of September 2011. Now, Clause 20, Subclause A of the agreement explicitly provided that possession will be given to the allottee within a period of 36 months of signing the agreement, with 6 months grace period in addition to the 36 months. On 28th of May 2012, housing project was approved by the Agra Development Authority. On 10th of December 2015 was the date of default as mentioned in Part 4 of the company petition on account of failure to provide the possession of the flats. On 31st of October 2017, the said project, Nikhil Park Royal, was registered with RERA. Now, the start date of the project was modified and the date of completion was declared as 10th of June 2019 in compliance with provisions of the RERA Act 2016. From 2018 to 2019, the flat buyers and respondent number 1 to 22 began filing claims before RERA, seeking refunds and compensation. On 25th of March 2020, as per the Supreme Court suo motu orders, period from 15th of March 2020 to 28th of February 2022, and an additional period of 90 days from 1st of March 22, whichever is longer, that is 31st of May 22, stood extended for purpose of calculation of the limitation. On 13th of October 2020, RERA wide order directed to refund the amount through monthly installments to the complainants. Now, while letter dated 22nd of December 21, issued by the District Magistrate to the Punjab National Bank and Agra District Cooperative Bank, in compliance of RERA orders, the District Magistrate seized the bank accounts of the CD and recovered the amount in tune of approximately 56 lakhs and repaid to some of the respondents, in addition to the payment some of the respondents had already received from the CD. In 2020 to 2022, nationwide lockdown caused impediments to completing the construction on time, as the entire labor was forced to leave the construction site unexpectedly. On 18th of June 22, RERA amended its earlier order by directing that amount should be calculated again by obtaining necessary documents both from the parties. On 30th of June 2022, there was an acknowledgement under balance sheet of the corporate debtor. Now, on 24th of December 2022, UP RERA wide public notice cancelled the registration of project of corporate debtor. On 12th of January 2024, company petition was filed by the answering respondent before Learned AA under Section 7 of the IBC, seeking initiation of CIRP against the CD. On 31st of January 2025, the adjudicating authority allowed the petition. Now, the present appeal was filed by the appellant Shailendra Agarwal, who was the suspended director of Messrs. NHA Infrabuild Private Limited, which is the corporate debtor, before this tribunal, being aggrieved by the order dated 31st of January 25, passed by the Honorable Allahabad Bench NCLT. Now, what were the issues before the Honorable Court? First, now corporate debtors' failure to hand over possession of the flats and its continuing default in refunding amounts to the allottees constitutes a continuous course of action. The limitation period under the Limitation Act 1963 is governed by Section 22, which provides that in the case of a continuing breach, limitation runs afresh with each successive instance of default. Now, Part 4 of the company petition mentions the date of commencement of default as 10th of December 2015. The corporate debtor's failure to hand over possession of the flats and its continuing default in refunding amounts to the allottees constitute a continuous cause of action. And since the possession of the units has not been handed over till date, it resulted in continuing default, recurring cause of action in terms of Section 22 of the Limitation Act in 1963. Now, the directions issued by UP RERA from time to time, including the refund order dated 13th of October 2020, its amendment on 18th of June 2022, and the project registration cancellation on 24th of December 22, reaffirm the subsistence of debt and the ongoing breach by the corporate debtor. Furthermore, the acknowledgement of debt in the corporate debtor's balance sheet on 30th of June 2022 extended the limitation period under the Section 18 of the Limitation Act 1963. Further, an acknowledgement of liability within the limitation period gives rise to a fresh period of limitation. Therefore, the Honorable Appellate Tribunal found that the present petition filed on 9th of January 2024, based upon the above facts and dates, is well within time. Now, the next issue is calculation of threshold limit under second proviso to Section 7, subsection 1 of IBC. Now, it is claimed by the appellant that the respondents' allottees do not fulfill threshold requirement under Section 7, subsection 1 of IBC, as 22 petitioners have filed application for 34 units. Total units allotted in the project are 247 units. As per claims of the appellant, most respondents either received refunds, partial repayments, or settled claims, thereby not fulfilling the statutory threshold of 100 or 10% of allottees for initiating Section 7 petition. Now, in terms of Section 7, subsection 1, 2 of the Code, an application for initiation of CIRP against a real estate developer must be filed by at least 100 allottees or 10% of the total number of allottees, whichever is lower. Now, in the present case, the total number of units in the project is 247, and the answering respondent collectively hold 34 allotted units, thereby meeting the statutory threshold. Therefore, the appellant's objection regarding the eligibility of certain allottees is without merit, as the answering respondent satisfies the threshold requirement under Section 7, subsection 1 of the Code. Now, the next issue is recovery certificates or decrees issued under the RERA Act. The appellant has also contended that home buyers who have obtained recovery certificates or decrees under the RERA Act are no longer allottees and therefore cannot be considered as financial creditors for the purpose of filing an application under Section 7 of the Code. However, This argument is untenable in the light of the Honorable Supreme Court's judgment in Vishal Chalani and others versus Debashish Nandar, RP of Buland Biltech Private Limited, wherein it has been categorically held that an allottee who subsequently becomes a decree holder under the RERA Act continues to remain a financial creditor in the class of home buyers and shall be governed by the threshold limit prescribed under Section 7, subsection 1 of the Code. The Honorable Appellate Tribunal notes that whether they have obtained recovery certificates or not, the respondent allottees remain financial creditors under Section 5, subsection 8F of the Code, as they have not received possession of the allotted flats and their deposited amounts have not been refunded in full. Also, the corporate debtors claim that certain applicants have settled their dues is also unsupported, as their outstanding amounts continue to reflect in the corporate debtors' financial statements. Now, the next issue is whether the company petition under Section 7 of IBC has been initiated fraudulently and with malicious intent. The Honorable Appellate Tribunal noted that the allottees' deposit amounts have not been fully refunded, and also their outstanding claims exceed the statutory threshold of Rs 1 crore. The mere fact that some applicants may have obtained recovery certificates does not preclude them from initiating proceedings under the Code, as long as the fundamental criteria of debt and default are satisfied, which has been established in this case. Also, the mere assertion that some allotments are disputed does not meet the rigorous standard required to invoke Section 65 of the Code. Moreover, if the certain allottees are excluded, the number of remaining applicants still satisfies the statutory threshold, rendering the present application maintainable. Now, the next issue is whether the corporate debtor can evade its pre-existing commitments by merely undergoing a change in its legal structure. This is as per Section 370 of the Companies Act 2013. The Honorable Appellate Tribunal noted that the corporate debtor, that is Messrs. NHA Infrabuild Private Limited, was incorporated through the conversion of the partnership firm Messrs. Nikhil Associates, pursuant to a resolution dated 10th of May 2022 and its execution on 6th of August 2022. Such conversion does not absolve the corporate debtor of its pre-existing liabilities, debts, or contractual obligations as per Section 369 and 370 of the Companies Act 2013. The principles enshrined in Section 369 reaffirm that the entity continues to bear the same financial and contractual responsibilities, and the present proceedings must be adjudicated considering the continuity of obligations post-conversion. Therefore, the corporate debtor cannot evade its pre-existing commitments by merely undergoing a change in its legal structure. So, friends, we conclude that the Honorable Appellate Tribunal did not find any infirmity in the findings of the adjudicating authority's orders and upheld its orders. Accordingly, it dismissed the appeal and directed that the CIRP process must continue. So, friends, we see here that the Honorable Court of our country has protected the interests of the home buyers and also upheld the legal sanctity of the various sections of the Code IBC 2016. So, friends, I trust that you find this both interesting, engaging. So, for further insights into such judicial pronouncements under the Code IBC 2016, please like this video and subscribe to my YouTube channel. So, thank you, friends, for being with me here today. This is Deepika B. Prasad signing off, and we'll catch you in the next case. Thank you.